Just hitting that real quick.
There we go. All right. So as I said, my name is Yusuf Abdul-Hafiz. I am the director of the Hippard Novice mock trial competition. If you want to introduce yourself, Chelsea.
Hi, I'm Chelsea Klump. I am the executive chair of the Advocate, so some of you have seen me before. And I'm here to tell you that we have another great competition for you with this one. This is one of my personal favorites. It has a very close place to my heart. It's my first advocacy competition that I did as a 1L, so you guys are in for a treat. And so I'm going to toss it back to you, Yusuf.
All right, perfect. So I'm going to screen share. Can everyone see that? Okay, perfect. All right. So a little bit about the Hippard Novice competition. It's an intramural mock trial tournament, which means that it's just UH students. It's a great opportunity to network because a lot of the rounds are going to be judged by local attorneys and judges. And at the end, there's going to be an opportunity for winning teams to actually get some cash prizes. So this is a really great way to like dip your toes into mock trial, figure out how like a trial works, as well as getting to meet other actual attorneys who'll be able to give you feedback and advice at the end of each competition, or each round, I should say. For who's eligible, the requirement is that you have to have less than a year of any, less than a year on any advocacy team. So you can't really be a part of the mock trial team, court team for a year. You also can't have already taken evidence or trial advocacy. That being said, if you are enrolled in evidence currently, we might make an exception, but it'll really depend on how many people register initially. So priority will be given to people who have not taken evidence, have not taken trial advocacy, 1Ls, but that doesn't mean if you're in evidence right now, you shouldn't register. Once the deadline passes, we'll let you know whether there's a spot for you or not. So how will Zoom work? So a lot of the things will still stay the same. It's still going to be business professional, at least from the waist up, or from what we can see on the camera. Competitors, judges, and witnesses will all log in via Zoom link that will be sent out. Witnesses are preferred to wear business professional, but business casual is fine. Just try not to go less than business casual. And then all your arguments will be given seated versus standing up if we were in real court. And on top of that, evidence, instead of approaching witnesses or opposing counsel, all that will just be done via screen sharing now. So the structure of a mock trial round. So before the actual round starts, there's something called housekeeping. This is where you get to do your introductions, introduce yourself, your co-counsel, and which side you're representing. And then you go into your motion in limine. Now, we'll break down each of these as the presentation goes on, but after your motion in limine, you'll go into your opening statements. Then the plaintiff will get a chance to present their case in chief, which consists of directing the plaintiff's witnesses, and then the defense gets a chance to cross them. Halfway through, there's going to be what's called a halftime motion that the defense can make. And then the defense gets to put on their case in chief. So they get to call their witnesses, do their directs, and the plaintiffs get a chance to cross-examine those witnesses. And then at the end of the trial, that's when you'll give your closing arguments. My screen froze. There we go. So housekeeping. Like I said, this is where you get to introduce yourself, what side you represent, and then you get to tell the judge that you're ready to proceed pursuant to housekeeping and a motion limine. That's if you have one. Housekeeping is usually not very substantive, but it's procedurally important. So this is where you ask questions like, may we assume all witnesses have been pre-sworn? May we assume all exhibits have been pre-marked? Just kind of like setting the ground rules, asking the judge what they prefer, what they like. And that's kind of that's your first opportunity to speak. So it's still important because that's your first impression with the judge, but it's not like it's going to be scored or anything like that. A motion in limine, that's once you do your housekeeping, this is The point of a motion eliminate is basically to prevent the other side from talking about certain things in their opening statement. So when you give your motion eliminate, you briefly summarize the case. So you say, Your Honor, as you know, today's case is about, and then you just insert 1 to 2 sentences of your version of the case. This is your chance to really be persuasive, let the judge know, like, this is what you're about to hear. Now, MILs is what I'll call it for short. They're usually in 3 parts, which means you raise 3 objections, but you don't have to do 3. You can do 1 or 2. It's really up to you and your discretion based on the case and what you think is like you don't want the other side to get into. And then you basically give the arguments. This last bullet point here, this is really the language that you want to use. We anticipate opposing counsel will talk about blank, or that a witness will say this. And then you give your explanation as to why the other side shouldn't be able to do that. So a common example is hearsay. If someone's testifying to what someone else has to say, you would raise the hearsay objection in your MIL. And if you have questions, feel free to drop it in the chat. Chelsea can address the comments or the questions, and we'll also get a chance to ask questions at the end. But everything will be shared on the website. There's going to be more material there for you as well as other references and resources. Okay. So opening statements. This is basically your chance to tell the story. So plaintiff will go first and the defense will go second. Ideally, you want to keep your opening statement in that 5 to 7 minute range, mostly because 1, you don't want it to go so long that the judge loses interest. But 2, you also want to make sure that you're not getting too argumentative. And we'll talk about that in a second. But basically, the structure of your opening is you introduce yourself to the jury. This is your first chance to say, like, my name is so-and-so to the jury. We're representing whoever your client is. And then you tell them your version of the story. You tell them what you think happened. This is where you get to preview evidence and testimony. So you'll say things along the lines of like, today in trial, you'll hear blank, or we're going to call Chelsea to come to the stand today, and she's going to tell you about what she saw the night of. She's going to tell you who she saw running away. She's going to tell you that she saw the defendant. You also have to explain the burden of proof. So burden of proof basically is that bar you have to meet. So there's preponderance of the evidence and beyond a reasonable doubt. So the case we're going to be using is a civil case, which means that it's just preponderance of the evidence. This is your chance to explain to the jury what that means, because someone who's not in law school might not know what that means. So you can try and come up with an analogy. I know a popular one is like the scales of justice. And you basically get to explain who has the burden and how much they have to prove it to you. Now, the case that we have, the defense has an affirmative defense. And what that means is the defense is also taking up a burden of their own. They have to prove something. And you have an opportunity to explain what that means as well. And then the last thing is you don't want to argue. So this isn't your closing arguments. This isn't like your chance to say like so-and-so did it. You're basically laying out like what the evidence will show, what witnesses will talk about, but you're not trying to argue this is why I'm right. So then we'll go into the 2 cases in chief. You have your direct examinations and your cross examinations. For the direct examinations, you don't want to ask leading questions. You want to focus on the 5 W's: who, what, when, where, and why. And sometimes you can even ask how. Basically, a leading question is saying like, Chelsea, you went to the store, didn't you? And that's basically implying what the answer is. I'm essentially leading Chelsea down to what the answer is going to be, and that's going to be yes, she did, or no, she didn't. But the proper way to ask that would be, Chelsea, what did you do when you left your home? And that would be, then Chelsea would go into like, oh, well, I went to the store. Then you go into your cross-examination. This is the opposite as direct. You want to ask only leading questions because keep in mind, the witness isn't going to be on your side. They're on the other team's side. And so they might get a little fighty with you or not give you what you want if you ask an open-ended question. You want to be very direct with your leading questions, and you want to keep it as simple as possible so that the witness doesn't have a chance to get kind of squirmy or weaselly with the answer. You want to try and get the witness to admit to your version of the events, your version of the story, as cleanly as possible. And then after the cross-examination, there's an opportunity for redirect. So the side that just directed will have a chance to go back up and ask some questions. If, let's say, something really bad happened on cross, you can try and rehabilitate the witness, try and fix any mistakes that might have happened. Now, redirect isn't required. You don't have to do a redirect. It's just there just in case. So it's a tool that you have an option to use or not use depending on how the cross-examination went. Offering exhibits. So there are a few exhibits in the case that we have for this tournament. I linked a website that has a really good, at least in my opinion, a really good layout as to how you introduce evidence. Since it is on Zoom, there are a few differences. So it talks about like, first you have to approach opposing counsel, but since we're doing this on Zoom and screen shares to everyone at the same time, you would just ask the judge instead if you're allowed to screen share outside the presence of the jury. So what that technically means is you just be screen sharing with opposing counsel, the judge, and the witness. But besides that, everything is fairly standard in that link. And there's an opportunity also when you try and admit an exhibit for objections. Speaking of, objections is something that you can do throughout the trial. Now, while you're not graded on objections, they're there so that you can essentially A, show that you know the rules of evidence, show that you can think on your feet, but B, they're mostly there to make sure that the other side plays fair. There is a long list of objections, but that link, the last bullet point there, that's a website that I like to use that, in my opinion, gives a really good way of telling you what the rules are, and then it kind of explains why we have those rules after. And at the end of the presentation, if you want to stick around, we're going to be going over some of the most common objections, how you argue it, how you argue against it, but that'll be at the end. Then after the plaintiff finishes their case in chief, at the halfway point, we'll do what's called halftime motions. The judge will ask, are there any motions at this time? And that's the defense's opportunity to make a motion for a judgment as a matter of law. Basically, what that means is you're telling the judge, look, Your Honor, they had certain elements that they had to prove by preponderance of the evidence, and they just failed to give any evidence to show that. I included the language below. Keep in mind, instead of beyond a reasonable doubt, it would be by preponderance of the evidence. But basically, this is your chance to tell the judge, like, we don't need to even present our case. The plaintiff has failed to meet their burden on their own. And while that's not scored, it's kind of similar to objections. It kind of shows that you know your stuff, you know how a trial goes, and you know how to argue, because the other side will get a chance to respond. And so it's one more opportunity to show that you know the rules and you know how to think on your feet. And then after the defense gives their case in chief, which was those directs and crosses and rebuttal that we already talked about, both sides will give their closing arguments. Typically, you want to keep your closing arguments between 10 to 15 minutes, depending on how much material came out in trial. The goal is to argue your theory and basically tell the jury why they should agree with you. there's three things that you want to be doing. You want to remind the jury about what they heard throughout trial, but you don't want to just rehash the whole trial. You just want to highlight the big things that happened in trial. And then if there were any exhibits admitted, you want to bring them up, show them the exhibits, show them how it connects to maybe someone's testimony or how it connects to your theory of the case. And then you always end by asking the jury to return a verdict in your favor. So find the defendant liable, find the defendant not liable. And the plaintiff has an opportunity for a rebuttal. So plaintiff will go, defense will go, and then plaintiff has an opportunity to do a 2 to 3 minute rebuttal. Now, something that the plaintiff has to do before they start their first argument is they just have to reserve 2 minutes or 3 minutes for rebuttal. So before the plaintiff gives their closing initially, you just want to say, before I proceed, Your Honor, can I reserve 2 minutes for rebuttal or 3 minutes for rebuttal? And that's kind of signaling to the judge that you're going to give a rebuttal and you know how the rules are set up and that you have to ask for one. Okay, so for the competition dates, we're going to have 4 preliminary rounds. They're on your screen there at those dates and times. Each team only has to compete in a minimum of 3 preliminary rounds to move on, but there will be an opportunity. If you can do all 4, then you're certainly welcome to do all 4. It's more experience, more practice, and more chances to meet new lawyers, new judges, and get some feedback. After the preliminary rounds, we'll have the quarterfinals, and from that point on, it's going to be single elimination. So it's going to be 1 round in the quarterfinals, and whatever team wins moves on to the next round. Whatever team ends up losing will be eliminated from the competition. And then you have your dates for the semifinals and the finals. So this will be uploaded, but if you want to put that in your calendar or take a picture, that's here for that. I'll leave it on the screen for a minute.
And we know that the 1L schedule this semester is a bit more extended than it's been in semesters past. So we try to be mindful about that so that if people have conflicts, that we're able to make sure that people get at least 3 rounds in.
Yeah, and when you go to register, there will be some questions asking if you have those conflicts. So make sure you put that down there so we make sure not to schedule you for a time where you have a conflict. All right. So credit requirements. So competitors who do the Hippard Novice competition can receive up to 1 hour credit. Basically, in order to get your 1 hour credit, you have to participate in all your scheduled rounds. So that's all the preliminary rounds. After that, you just have to turn in a written copy of just 3 of your 5 statements. So that could be your direct, cross, and your opening. It could be a motion eliminate, opening, direct. Really doesn't matter which combination of 3, but for the most part, you should have at least 3 things written out before the competition even starts. So all that is just turning it in. So I'm aware that you're completing it for credit, and I can see that you at least tried. There are competition credit limits, and you should probably review the student handbook if you're not aware about how the credit system works, especially since they kind of revamped it recently this past year because of COVID. But you can get up to 4 competition credits. So basically what that means is you could do Hippard Novice and maybe 1 other competition this semester, and then you could do 2 open competitions next semester. And then you could get your 4 competition credits that way. But if you do 5 or 6 competitions, just know that you're capped at 4, so you can only get credit for 4. So registration will start tonight at 6 p.m. To register, there is a cost. If you are an Advocates member, it's $10 per person. So if you're both members, then it would just be $20 for the team. And then if you're not an Advocate member, it would be $50 per person, or $100 if both of you are non-members. In my opinion, if you're planning on doing 2 competitions, you might as well become a member because it's going to pay for itself at that point. I did 4 competitions, so I ended up saving a lot of money by being a member before I did my first competition. And you have the opportunity to become a member up until the registration, or like up until you register. So make sure you become a member before you register, because if you register and then become a member, it's going to be tough. So you want to do it before you register. And then if you have any questions, you can feel free to email me. I also linked the website. There's at the top, there's a tab for competitions, and the last one is competition resources. So that's where this PowerPoint's going to be, as well as some other resources to help you write your openings, directs, crosses, evidence, stuff like that. But I'm pretty sure Chelsea's been answering questions in the chat. But if anyone has any questions that they want to ask, you can feel free to unmute right now, and me and Chelsea can try and answer it. No questions? All
Also,
right.
just something else that may be helpful to you guys as well. So in addition to our advocates YouTube page, which is where this recording is going to be posted and that link will be distributed, there's also the Blakely Advocacy Institute. They have their own YouTube page as well. And that's where we've been live streaming other types of competitions. So the mock trial team had an intra-team competition at the beginning of last semester. So that's an example of like a mock trial round that's really strong. In fact, Yusuf competed in that and won. Yeah, and he bless Mario's heart. He like destroyed their expert witness. So if you want to see what that looks like, that's a good resource. It's the Vincent LaGuardia Gambini, the VLG finals. And then also for the Hippard Open mock trial competition that we had last November, that final round is there as well. So I remember whenever I did this as a 1L, I did not know what this looked like. I did not know how like housekeeping sounded or what emotion and limine looked like. And so these are really helpful examples, from the school that are recent that you guys can also take advantage of and kind of get some ideas.
Yeah, if you've never seen a trial before, I highly recommend, if you have the time, to just go in and watch like what an opening looks like, or a direct or a cross, just because that's a really good way to learn how these things go.
And also, as well, you've mentioned it in here a few times, but this will be a civil case. So just, right now it's going to be plaintiff, defendant, liable, not liable. The burden of proof is going to be by a preponderance of the evidence. So I just want to make that that clarification right there, because I know whenever I was a 1L, I did not realize that there was a distinction. And in my closing, I was like, the evidence supports and justice demands finding of guilt. He's guilty. And the judge who gave me feedback after was like, okay, so it's going to be liable or not liable. Okay, this is civil. So just another helpful little tip. Okay, and Nikki just asked a question. So you'll know what the case is about whenever it's distributed after registration ends.
Right.
No hints, just that it's civil.
All right. If there aren't any more questions, we can go into evidence. If you already have an understanding of evidence or don't want to stick around, you feel free to leave whenever. I will say evidence is very complicated. There's an entire course on it. So I will do my best to give you the SparkNote version in the few minutes that we have. All right. Oh, there we go. Okay, so one of the biggest objections that you'll hear in a trial is hearsay. The official language of hearsay is any out-of-court statement being offered for the truth of the matter asserted. So what that means, in as simply as I could break that down, is if you say something outside of court, doesn't matter where you are, if you're outside of court, it's an out-of-court statement, and it's being offered for the truth of the matter asserted. What that means is essentially what you're saying is what you mean. Like the words themselves mean what you're saying. So the example here is John said yesterday, the light was red. So the truth that's being asserted is that the light was red. And that's all that's being asserted in that sentence. So anytime you make a statement about something or how things were, those are all out of court statements being offered for the truth of the matter asserted. I'd say maybe 75% of the time, if you hear someone in court say, John said this, or what did they say, that's going to be hearsay. Now, there are some exceptions. There's admission by a party opponent, which means that, let's say it's Yusuf v. Chelsea. I can use any statements that Chelsea said. So it doesn't matter what she said, where she said it, when she said it. I can say on the stand, or I can put on any witness on the stand that said, Chelsea said this. And then vice versa also applies. Chelsea can put on any witness on the stand to say, Yusuf said this. So whoever your party opponent is, you can use any of their statements throughout any point in the trial. Then there's an exception for excited utterance. Basically, an excited utterance is what it sounds like. If you're excited and say something or blurt something out, scream something, as long as you can show the judge that this person is excited when they said it, it's probably going to get in. So a common example is if you almost got hit by a car. That's a stressful event. That's a startling event. Anything you screamed right when that happened while you were excited would be admissible. Then there's present sense impression. So that basically means like you're describing an event or something that's happening as it's happening. So the car almost hitting me. An example would be if I saw it across the street and I said, oh my God, that car almost hit Chelsea, that would be a present sense impression because I just witnessed it. I'm describing what I'm seeing. Then there is business records. So basically, if there's certain steps that you have to meet, and that website that I linked earlier in the objections page does a great job of breaking down all the things you have to show. But if you have any business record or like someone who works at a business who produces a document, like for example, like a bank produces bank statements, you can usually get into that kind of stuff through a business record exception. And then the last one is effect on the listener. So you would use effect on the listener because let's say I'm having a conversation with Chelsea and I said something to Chelsea. Technically what I said was hearsay, but you would argue we're not using it for the truth of the matter asserted. We're using it for the effect it had on the listener, Chelsea. We care about how Chelsea reacted to what I said. And so like if I said something startling and we want to get Chelsea's reaction to that, I can bring out that statement to show Chelsea's reaction to it. So that's what the effect on the listener kind of means. We don't really care what the statement is. We care about how the other person who heard it reacted. So that's the simplest way I can break down hearsay. There's like 30 exceptions to hearsay and like 6 other rules that make things like technically hearsay or not hearsay, but this is the simplest way to get it. So if you're in trial and you hear someone say, John said blank, or I heard blank, there's a good chance that you're about to hear hearsay, and that's a good chance to object and show that you know what hearsay is, and you can kind of argue, oh, he wasn't excited when he said that, or he wasn't describing what he saw. That gives you kind of a chance to argue that before the judge.
And also,
Leading
real
question.
quick too. Oh, I just wanted to make another quick point about hearsay. Things that are written down also count as hearsay. So, like a contract, if you write somebody a note, like "I'm gonna kill you," or like if you make like a little drawing, like a schematic of like a house or something, that all counts as hearsay as well. It's not just spoken statements; it can also be written.
Yeah, anything written also counts as hearsay. Leading question, we kind of talked about this. This is basically if opposing counsel is doing their direct and they ask a question like, you saw him do it, right? They're leading the witness. That's your chance to object to leading, show the judge that you're listening, first of all, and that you know the rules as well. Speculation is basically what that means is a witness can only testify to what they know. So if Chelsea's my witness, I can't ask Chelsea, oh, what was Mark thinking? Chelsea's not Mark. She doesn't know what Mark's thinking. The only way for Chelsea to know what Mark was thinking is if Mark told her, oh, I'm thinking this. But unless Mark does that, Chelsea would be speculating. So you can't ask a witness about something they don't know about. If they weren't at a place, you can't ask them about like what so-and-so felt or thought. You can only ask a witness about things that they can perceive. So if it's something they can see, hear, taste, touch, whatever, that's something you can ask a witness about. But if it goes outside of your 5 senses, then it's going to be speculation. Improper character evidence. So what this means is you're using a prior bad act to prove a current bad one. So the example I have is, let's say Hector stole a candy bar from a store a year ago, and now Hector's on trial for theft. I can't bring up that prior bad act of him stealing to try and prove like, oh, well, he stole in the past, he would certainly steal today or steal now. So that's what improper character evidence is. Relevance, so that's going to be 401 or 403. And when you go to that website, just it'll have the numbers there so that you can look them up. Relevance is basically, is the testimony relevant to the elements that either side has to prove? So you just ask yourself, does what this person, what they're saying, or what this piece of evidence show, does it make any fact in today's case more or less likely? So it doesn't just have to make something more likely. You can use evidence to show that it's less likely. Like if you have an alibi or something, you can introduce an alibi to show it couldn't have been me, I wasn't even there. So-and-so can tell you that. Basically, this is your chance to explain to the judge why we should or shouldn't care about this information. So if you're there for a murder charge and they start telling you about their hobbies or something like that, chances are that's not going to be relevant to the case. It's not going to be important to proving whether or not the person actually committed the murder. I think that's my last one. So yeah, that's just a quick overview of evidence. Those are probably your most common ones. Like I said, feel free to go to that website that I linked on the objections page, because it really breaks down not only the ones that I covered, but a lot of other objections and exceptions. So you're not limited to just the ones that I talked about. You can try and raise any objection that you think you can make, or argue any exception that you think you can make. I see there's raised hand. Is there a question?
Yeah, I have a question. So you said that on cross you can ask leading questions, but then you just said that it's also something that you can object to. So can you explain that?
Just to clarify, you ask leading questions on cross and only cross. If you're directing a witness, your questions are not allowed to be leading. They have to be open-ended questions. So like that, who, what, why, where, when. And if the other team is doing their direct and they start to ask leading questions, that's when you would raise that objection, because you're only allowed to do it on cross examinations. Does that make sense? Does that clarify that?
Yeah, so basically you can only raise the objection on a direct, I guess, examination, not on a cross.
Yes, exactly.
Okay. Thanks.
Any other questions? And feel free to ask questions, because evidence is an entire course that is taught for a whole semester. So chances are I might have struggled to explain in the 10 minutes we had.
I have a question. So for the last trial competition, I like signed up for it like at the last minute, and so I paid my dues for it, but I actually didn't do the competition. Can I just like transfer that payment over to this?
So go ahead and email me,
Okay.
and then I'll get with the finance chair and we can get that moved over for you. Yes.
Any other questions?
See, Chelsea, other Chelsea has her hand up.
Oh,
Yeah. Anytime you mentioned Chelsea, I was like, what? What do I have to do with this? I don't know anything. So between the close of registration and the time of the competition, it's really short. So I'm just kind of wondering about how much is going to be involved, the expected time preparation, and I guess resources that will be given so that we actually know what to do beyond like, the links in the PowerPoint today.
mhm.
So a
Yeah.
lot of that, it is really short. This is the time period that we have for all of our competitions, which again, yeah, it does seem really short, but you'd be surprised how much you can get through. You'll get the competition packet. It'll seem daunting, but they always read really quickly. I mean, so if you do kind of a lot of the prep work yourself at this point, like kind of looking at those resources and becoming acquainted with what's required and that kind of thing. Because there are things like housekeeping that they're going to be mostly the same regardless. And, so you're going to want to think of, okay, like this is the theory of the case for both sides, because you will have to argue for plaintiff and defendant. And, you're going to have to prep your witnesses. And honestly, it sounds really, really intimidating. Mock trial always does, because it is like a full simulation of a real trial. But I promise, like, once you get through the first one and you get a feel for it, it feels much easier. And a lot of the mistakes that you maybe made in that first round, you learn from that and you're able to really adjust once and you're going to get feedback from real life attorneys who are going to be like, hey, this was great, okay, you did this, like, I know this, like, you're a one on this, your first time ever doing this, but like if you did this in practice, then blah blah would happen. So everyone's kind of on the same like level, on the same footing with the Hippard novice competition. That like everyone's kind of doing this for the first time, it's your first taste of it, and it seems like a lot, but I promise you can rise to the occasion and do it. And from that first round to that third round, you are going to be so surprised at how much more comfortable it feels and how much you've learned and how much, different kind of what you're doing now versus that first round is. And Yusuf did a great job of explaining. Whenever I did my first round, I didn't know what emotional limiting really was. When it said emotional limiting in 3 parts, I thought that was one thing that I wanted to keep out, and I had to come up with 3 reasons why. But luckily, I was defense on that round, and so when the plaintiffs went first, and I could kind of see, oh, they're picking 3 things. I picked 2 other things on the fly, and that's really how it is. And whenever I did my first direct examination, I tried to cover every single thing in the fact pattern, which, now that I've done this for a few years, I'm like, wow, that was a mistake. But that's the thing, is this is your first opportunity to get into it. And this is the place to kind of make those mistakes, those rookie mistakes, is now when the stakes are low, whenever everyone's kind of learning together. So, I will say it's work and it does feel stressful, but it's not all for naught. Like, you really are going to walk away with a lot of good skills if you do end up registering for the competition.
Yeah, and I will say also on top of that, a lot of the work for mock trial will come at the front half. So when you get the problem and you're reviewing the problem and trying to think of a theory and like figure out what's going on, like that's where a lot of the work will come in. And then once you get like your idea of like, okay, this is the chain of events, this is what we're trying to prove, then your opening, your directs, your closings, your crosses, those will come more naturally because you already know where you want to go with your direct. You already know what you want to talk about in your opening. It's just a matter of getting it down onto paper once you get through that initial step of trying to figure out the problem. And I will also say the problem we picked, or the problem that One of our judges, Judge Weems, picked for us is a more straightforward problem. It's on the shorter side. It's not that complicated. So hopefully that will also make things a little easier on you all.
And a good pro tip too is whenever you get a mock trial packet, there are going to be jury instructions included in the packet. So I would kind of, get an idea of what's happening with this case and go to those jury instructions and say, okay, I'm the plaintiff. My burden is this, and this is what I'm trying to prove. Or, okay, I'm the defense. Where is this weak? And kind of start building your theory from there. It's a good place to start. And also one more thing that I'll say real quick, because y'all haven't done this before. So like I said, you're gonna have to try both sides of the case. So maybe one round you'll be plaintiff, maybe the next round you'll be defense. And so you're gonna have to prepare the witnesses who you get, for both sides. And also whenever you're questioning someone, you're the person who's questioning them. And whenever someone's doing their cross-examination, you're the person who's going to be making objections, not your co-counsel. The term is one horse, one rider. And I just mentioned that because it comes up a lot. So just kind of something else to be aware of. You're going to have to try both sides. You pick one witness to direct. Your partner's going to pick the other witness to direct. You're going to pick one witness on cross. Your partner's going to pick the other witness on cross. And that's your witness. And if you need to make objections, you're the one who makes the objections there. So just a little bit more overview to overwhelm you before we send you on your way.
And if you do have any questions, or when you're working through the packet, like confused about something, not sure about how something works, feel free to email me. I can answer any general questions about like the structure, what you're supposed to do. The only questions I won't answer is like if you try and ask me like specifics about like your theory, or like, is this a good question to ask, or is this like a good opening? I won't answer like any specifics, just so that I'm not like helping certain teams and not others. But if you have like a general question of like, I don't know what to say after objection, then like send me an email and I can like give you like a script, or like this is some examples of what you can say or how to say things. So feel free to email me at any point before the competition starting. Unless there are any other questions, I think we've covered everything. You guys are free to leave whenever. And we will also be posting this recording up on the YouTube channel that Chelsea talked about earlier. So if there's something you forgot about, you can go back and watch it.
Yep. And registration opens tonight at 6 p.m., y'all. So be on the lookout.
Yeah, I'll just stick around just in case there was any other. Oh, it's like everyone. All right.
Okay, so I guess.
Actually, I had a question.
Okay, yeah, sure.
Sorry about that. What was the YouTube channel called again? I missed it.
So there is a YouTube channel where learning lunches are posted, and that is our Advocates at UHLC YouTube page. And we'll be distributing a link to this one in particular, to the one else after the call, after we get that uploaded. But as far as those final rounds of mock trial competitions, those are all on the Blakely Advocacy Institute's YouTube channel.
Okay, that was what I was asking about. Okay. Got it. Thank you so much.
Absolutely.
Yep. Thanks for coming.
Bye-bye.
Okay, so let's stop recording.